Call on Government Order of the Day number 1.
Employment Relations Amendment Bill, committee stage continued.
I declare the House in committee for further consideration of the Employment Relations Amendment Bill.
Mr. Speaker.
Mr. Chair.
These get away, wasn't it? Order. When we were last considering this bill, which we're in committee for now, the Employment Relations Bill, we were debating part 2. Ian Lees-Galloway has the call and has 2 minutes and 28 seconds left if he so wishes. He appears not to.
Mr. Chair.
Sue Moroney.
Well, thank you, Mr. Chair. And in beginning my contribution on part 2 on this bill, I was very remiss yesterday in getting quite excited about getting the call from you, sir, in your capacity as the Chair for the first time, and failed to congratulate you on your election to that position. So I take the opportunity now to do that and look forward to taking many calls under your chairpersonship and your speakership, in fact. So part 2 of this ugly bill, I've got to say, that is the first act of this government under its new term, and of course, yes, they are on the attack of workers. And part 2 is the part that really bothers me, because while much of the destruction is done in part 1, actually what part 2 is about is the way in which all of this destruction is going to be brought about in the workplace. And what it does unusually, as Ian Lees-Galloway was saying in his contribution yesterday, is it actually is retrospective. And we hardly ever deal with retrospective pieces of legislation in this House, but when it comes to attacking the rights of workers, that national government has no shame. And part 2 is where they make this retrospective, because what they say in part 2 is that in this drive to make sure that there is no need to conclude collective bargaining, that there would be no obligation on parties to actually conclude and come to a collective agreement with each other about wages and condition. In their hurry to do that, they want to make sure that employment negotiations and collective employment agreement negotiations that are already underway are going to be captured by this piece of legislation. But in order to understand why they've done it this way, I think we need to backtrack a little, Mr. Chair, because the history is this. The national government really wanted to pass this piece of legislation about 4 or 5 months ago. But there was one big problem. They lost the numbers. They lost the numbers to pass this legislation because John Banks had to leave Parliament because he's on his way to jail. That's what's actually happened here. They wanted to pass that legislation at that point in time, but when Mr. Banks had to relinquish his seat in this Parliament, the government no longer had a majority in which to pass this piece of legislation. That's how bad it is. Their other support partners at the time would not support it. They would not support it because they know the damage this is going to do to the New Zealand workplace, and they know the damage that this is going to do to workers and their families. And at a time when we face increasing child poverty in this country, what is the current government doing? It is moving to ensure that wages will be lowered, that wages will not be able to increase with cost of living, because there will be no pressure, no legislative requirement on employers to conclude bargaining and to actually have bargaining result in a collective employment agreement. So, part 2 quite specifically says that when it comes to collective bargaining, that it applies to all bargaining, whether the bargaining commenced before, on or after the commencement of this piece of legislation. So workers who are currently engaged in collective bargaining with their employer are going to suddenly find on the passing of this bill that their employer will not be required to come to conclude an agreement with them. Because right here as we sit here in New Zealand today, they are undertaking bargaining. A lot of them actually in the health sector, interestingly enough. A lot of them in the health sector are undertaking bargaining at the moment. And it's those workers that this government is after. A lot of expired employment agreements happening in the health sector. So right now as we sit, they are engaged in a bargaining process. And what the law currently says is that there is a requirement to conclude bargaining and for it to result in a collective employment agreement. It's a very rational and sensible thing that has actually seen New Zealand through quite an interesting period of time where there has been, the economy has been in recession. And Mr Chair, Mr Chair.
Sue Moroney.
Thank you, Mr Chair. Where the economy has been in recession, and yet there have not been extraordinary outbreaks of workers making unreasonable demands and using this part of the legislation to hold their employers to ransom. We have seen none of that. We've seen absolutely none of it. So I asked the question yesterday and still haven't had an answer from anyone opposite about where can they cite the example of employees, of workers making unreasonable demands and getting unreasonable wage increases because of this duty.
Order. I'm just now going to advise the member to come back to part 2 of the bill, which couldn't possibly involve questions that were asked yesterday.
Thank you, Mr Chair. So the duty to conclude bargaining is the part that part 2 actually says can start happening before the Act is even passed through this Parliament. That's the point that I'm making. That actually this is unusual that it's done in this way because many of those workers are engaging in collective bargaining right now. They are already in that process, and yet this part 2 says that doesn't matter that they've already initiated the process, and when they initiated it a whole set of different laws were in place. This part says that despite that, if they have initiated bargaining before the commencement of this Act, the rules are going to change. The rules are simply going to change midway through their bargaining process on them. Why would that government be so bloody minded about having retrospective legislation? Well, I think the answer is here. The number of employment negotiations that are underway in the state sector, the sheer number of them. And I think health is going to be one of their major targets because we've got the resident medical officers MECA that's been negotiated at the moment. We've got the radiation technologists who are negotiating their collective at the moment. We've got the sonographers. We've got the clerical and administrative workers in the health sector who are negotiating. We've got the clinical physiologists. We've got sonographers. Importantly, we've got the nursing one. That's the big one that's coming up. That's where the big dollars are to be saved by this government, and that's what they're after. They want to suppress the wages and conditions of nurses working in our public hospitals. But then we go on to the education sector, and we find that there are a few coming up in that regard as well. I think this is what it's about. The Secondary Teachers Collective Agreement expires on the 30th of June 2015. And that government cannot wait to make sure that those teachers are going to face a situation where the cards are all on the employer's side because there is no duty to actually conclude collective bargaining. It is the teachers and the nurses and the police and the firefighters and all of the other important public servants who we rely on for our social services in this country that government is after, and it's absolutely plain in part 2, because they are making sure that the nurses' employment agreement, which is up for negotiation at the moment, will be captured by this duty to not conclude bargaining. So it's absolutely clear that part 2, and as I said before, it's really unusual for there to be retrospective legislation passed in this Parliament. Why is it that this government would be so keen to make sure that this legislation applies to bargaining already underway? Well, it's clear that it's because of the types of work that is existing at the moment. And I've listened carefully to those ministers as they've argued about containing the cost of public services. Well, when it comes to our education and health services, that can really only mean one thing. That can only mean that they're after wages. Now, thinking about the wages of the nurses who are going to be affected by Part 2, because Part 2 is going to apply to them even though they've already initiated collective bargaining. Thinking about their wage movements, they have virtually not had any wage movements under the national government. They have had, over the course of the last 6 years, about 6% increase in their national collective employment agreement. That is less than the rate of inflation. So the nurses have already been paying for the savings that the national government's been making in its surplus, in its bid to make its budget balance.
Denise Roche.